All right, we are now streaming live on YouTube. This is the bond hearing for Andreas Thompson, charged in warrant number 2024 CW 70810, criminal attempt, 70811, aggravated battery, 0778, aggravated assault, and 0779, criminal attempt, and 0780, weapon possession during the commission of a crime. Representing the state is Attorney Freeman. Representing the defendant is Attorney Render. Attorney Render, your witness or your motion.
Yes, Your Honor. Your Honor, Mr. Andreas Thompson is 20 years old. He grew up right here in Riverdale. He has deep ties to the community. His family is watching via YouTube. They did want to be present, but I did let them know that this was only for witnesses speaking, and they did want to show their support. However, he's been in Atlanta his whole life, born and raised. He graduated from Charles Drew High School in Riverdale. He lives not far from the courthouse. I could provide that address once I confirm with mom. He was currently working. Right now, he does not have that job. Unfortunately, he's been incarcerated for about, I think, since he's been incarcerated for over, let me see, I believe it's over a month or two. No, I'm sorry, March 21st, Your Honor. So, in about, let me see, 14 days, he'll be entitled to bond. I don't believe that this case will be indicted within 2 weeks, Your Honor. But his co-defendants were all given bonds of $100,000. His brother and his cousin are his co-defendants. He did not have representation at the time, and so he did not move forward. But now we're in front of the court asking for a bond. He has no criminal history, Your Honor. He's never been arrested. He has no FTAs. Well, I'm sorry. He might have been arrested, but I know he has no criminal history. He has no failure to appears, and he has no children at this time. The facts that come arise in this case is simply a drug deal gone bad, and it's going to be the state's contention that their victim, the actual drug dealer, is the victim. But it's going to be the defense's standpoint that this guy was actually robbing these young men, and that's why they came upstairs. So essentially, a drug deal was taking place. Mr. Andreas and his cousin got a call that something was going on. They came up the stairs, and at that time, Mr. Andreas was actually shot. So Mr. Andreas did actually suffer in this incident, and so based upon that, Your Honor, I know his co-defendant's bonds are $100,000, but based upon his suffering and being a victim in his own right, I believe his case is a little stronger than theirs. I do believe that a $70,000 bond will be appropriate for him in this matter. I know it's aggravated assault, criminal attempt, armed robbery, possession of firearms on conviction of a felony, and I know that these are extreme charges. I know his family is very, very intense as far as communication, as far as cooperation and moving forward. I don't believe he will be a risk to flee the jurisdiction. I believe the past is indicative of the future. I don't believe that he's a risk to reoffend. He has no contact with the victim. He did not know the victim. It was someone that his cousin knew. So I don't believe he has any contact with the victim. He will not be a risk to the victim. He's fine with any ankle monitoring that the court is requesting, although his co-defendants did not receive that. If that would amount in a lower bond, he would accept that as well. But at this time, Your Honor, we just indicate that Mr. Andreas is a young man caught up in a situation, and he's looking for a reasonable bond at this time to fight this case.
Thank you, Judge. And I do want to give one correction, and I just pulled up one of the co-defendants. Is not a total of 100,000. One of the co-defendants has the same 5 charges and has 25,000 on each charge.
How much are you broke up? I'm sorry, I'm Freeman. You broke up.
Okay, so one of the co-defendants, I just put up one of them just to see, and it's not a total of 100,000. Each they're the same 5 charges, and that co-defendant has 25,000 on each charge. Okay. And actually, what I was going to ask for is that this young man remained on no bond status. But if the court is inclined to grant a bond, I was going to ask for at minimum $25,000 on each charge. This was a case where this young man and the co-defendants planned to rob a trap house. And that's what it was. And so when this young man's crew or whatever went to the door of the trap house, the people in the trap house knew something was going down and shots were fired on each side. And yes, Mr. Thompson was shot in that. But I just wanted to be clear, this was a situation, in testimony, there was a hearing on one of the cases, but this was a case where Mr. Thompson and his crew planned to rob a trap house. Our victim in the case, regardless if he was an alleged drug dealer or not, he suffered serious injuries. And the last I knew, when I asked the detective during the hearing, he was on life support. I don't know the status of that young man at this time, but he was on life support when I last checked, Your Honor. This is a serious case, serious injuries. And so I certainly believe that no bond status will be appropriate. But again, if the court is inclined, I would ask for at minimum $25,000 on each charge. I do not show any prior convictions for this young man's history. But again, Your Honor, for he being so young, 20 years old.
That's what I was about to ask, how old he is. Okay.
20,
Yeah.
to plan with his crew to rob a trap house. I don't know anything about this young man's education or whether he was working, but surely at 20 years old, he should have been doing something else other than planning to rob a trap house. And so with that, Your Honor, and I know the family of my victim is watching also, and they have expressed to my office on many occasions that they are opposed to bond. But again, Your Honor, and I'm showing the warrant was taken out on March 26th. So I'm not sure exactly the date when this young man was arrested, but we are asking for no bond status, and again, in the alternative, $25,000 at minimum on each charge, with a curfew and a stay away order.
Any final words, Attorney Render?
Yes, Your Honor. I wasn't present at the preliminary hearing, but from my understanding, there was no definitive proof that this was actually a pre-planned scheme or conspiracy that would actually tie my client into actually having knowledge that this was going to take place. So I understand the state's position, but I don't believe there's any evidence presented that particularly my client, Mr. Andreas Thompson, planned, schemed, and had a motivation to rob the alleged victim in this case. Again, like I said, my client was under the impression that his family member was getting robbed, and so in his reaction, he was fired upon when he arrived. So, Your Honor, again, I understand the state's position, but the co-defendants do have bonds, and so we're asking for a reasonable bond at this time to reflect the co-defendant's bond and the fact that my client was shot as well.
All right, so no history, 20 years old. He was shot. You said he was born and raised here in Riverdale?
Yes, Your Honor.
And all his family lives here?
Yes, Your Honor.
So, there's always a threat to the community when we have young people running around with guns. I mean, I don't know. I mean, he's not charged with, well, he is charged with possession by, what is that, possession by?
Possession during the commission of a crime.
Okay. So I'm not sure if it was a legally obtained gun or not, but he's not charged with that. But it's very concerning because This is what we see every day. This is what we hear every day, is young men running around here with guns, shooting innocent people. And so I do have some serious concerns with Mr. Thompson's threat to the community. However, I am going to set a bond. All the other co-defendants have a bond, so I will set a bond. But I want a series of special conditions, of course, not to have any contact with any of the co-defendants. Curfew. May not possess a weapon. May not leave the state of Georgia without permission. So, Mr. Thompson?
Yes, ma'am.
I'm not sure what's going on with you. As Attorney Freeman was saying, you're so young, but this is not where you want to be. This is, I promise you, this is not what you want. Sounds like, based on Attorney Render's presentation, that you have some supportive family. That was encouraging to hear. And that you have people that's willing to get you through this. But you're definitely starting out wrong, sir. So I am going to set a bond. It's total five charges?
That's correct, Your Honor.
Okay. I'm going to set the bond at all right, so this is what I'm going to go by the charge. So for the fire, and you guys will have to help me count this. I won't know what I don't know what the total amount is right now.
Okay.
So for the firearm possession, that's 20. For the criminal attempt, that's 10. Aggravated battery, that's 25. Aggravated assault, 25. And the criminal attempt, 10.
So the criminal attempt for armed robbery, 10,000.
Oh, wait, no, I'm sorry, armed robbery. I didn't realize. Hold on.
The attempt is armed robbery on both of those.
Okay, hold on. So, I'm gonna do a total bond of 90,000, if you can just make it work.
Okay.
Yes, Your Honor.
And then, okay. So, Mr. Thompson, if you come back on a revocation, you won't get this blessing, okay? Because initially, before your counsel presented, I had looked at the facts of this case and had already determined that the facts were egregious, and a possible no bond is what I was going to consider. So I don't want to see you back.
Yes, ma'am.
Good luck to you, sir.
And Shannon, I'll get that order to you for you to sign and return it.
I was going to say, I don't want to leave you guys so fast, but I got another courtroom to go into.
Right.
All right.
It was good to see you, Judge, as well.
Good to see you.
Thank you, guys. Have a good weekend.
All right. Have a good one.
Good weekend. All right, Attorney Lewis, you ready?
Yes, ma'am.
And which one you doing? Hayes first?
Yes, ma'am.
All right, if you can bring Mr. Hayes, Deputy. I'm just gonna stay on YouTube.
Yes, ma'am.
Here's Mr. Hayes, Judge.
Mr. Hayes, this is your bond hearing, for warrant number 2024 WA 76927, aggravated assault. Representing the state's attorney, Cheryl Freeman, representing the defendant is Attorney Lewis. Attorney Lewis, your motion.
Thank you, Judge. Judge, before you is Mr. Hayes. He is accused at this time of a single count of aggravated assault. The aggravated assault is, of course, his use of a handheld taser, not the type that the police have, but one of the touch instruments against a Mr. Ashton Green, while in Mr. Hayes's home. Judge, we heard a number of facts on our hearing that we had on this matter at preliminary hearing, but the sum total is that Mr. Green did not possess a weapon. Mr. Green had been an invitee to the home by a Mr. Stoner, and that while in the home, Mr. Hayes, who also resided there, after being called some provocative words, used a taser on Mr. Green. Judge, we elected at that hearing to not present any evidence because, frankly, we did not have the body cam of the police officer, and we felt that the unsupported testimony of Mr. Stoner, in contradiction to what was told to you by the police, would not be persuasive at this time towards the court. Today, we are here, of course, on this bond hearing for my client. My client is 34 years of age, Judge. He has been a resident of the state of Georgia for over 2 years. He resided at the address of the incident, and a conversation with Mr. Stoner this morning leaves us with him being invited to return to that home as well. Prior to that, he lived on Park Lake Boulevard in a different apartment that's in Atlanta, Georgia, and he had resided there for over a year. His family, Judge, however, lives in Alabama. That is where he's from. He doesn't possess any physical or psychological issues that we are aware of or that he is aware of. He does have his general educational diploma, Judge, and I, of course, always inquire as to why a person ends up with a GED rather than going through school. And he just said it was just something that was available to him, and he took it, and he, of course, regrets dropping out of school, but nevertheless, he did. And he went back and got his general education diploma after doing that. He has been gainfully employed by cash movers. Cash in this instance is spelled K-A-S-H. And Daryl, his supervisor, is at Cash Movers. He has worked for them for over a year and a half, Judge. He is a convicted felon, Judge. He was convicted for forgery in the state of Texas. He was on probation. He successfully completed that probation. But nevertheless, I don't have anything that says that Texas has a first offender kind of a statute as does Georgia. But we recognize it as a conviction. He has a single failure to appear, Judge, at a court and that is because he was confined at the time. And in essence, he couldn't convince the people that were holding him to let him go to that court date. He is presently on probation out of DeKalb County, Judge, for possession of false identifications. He has 2 years remaining on that probation. I'm sorry.
I didn't say
Oh, I didn't
anything.
say anything.
Okay. He has no other open cases, Judge, that's out there. He has no children, Judge. Judge, he does not present a danger to Ashton Green, who was identified by the police, by Clayton County Police Department, as the victim in this case. Of course, we contest that description, but nevertheless, they did. Although the Clayton County Police Department did not see it prudent, the Mr. Green has been arrested on his 2 warrants that
Someone
existed.
object. That's not relevant regarding the bond for Mr. Hayes.
It is relevant as to whether he will have any influence over this victim or witness to this case. I believe that is an IALA factor.
I don't believe whether or not the victim has been arrested or not is relevant.
But that's not relevant. I agree, Attorney Freeman. That's not relevant, Attorney Lewis.
All right. So his arrest, I understand now where her objection is.
Yes.
Mr. Green's confinement is in the Fulton County Jail on both of his warrants.
It's just the same objection.
Yes, Attorney Lewis, move on.
I am there, Judge. This is influence to the victim or witness.
Okay, the court is upholding Sheriff Attorney Freeman's objection.
Okay, so we don't.
Objection sustained, so don't go into the victim's criminal history at all.
Oh, I see. All right. So in summary, he won't have access to the alleged victim or witness in this case.
Okay.
And so, Judge, all of that being said, we'd ask the court to grant bond in this particular case. The ties to this community have been identified. The access to victims and witnesses have been identified. The flight risk has been spoken of in this particular case. And so we'd ask the court at this point in time to grant him a bond. Thank you.
All right, thank you. Attorney Freeman?
Thank you, Judge. We're asking that Mr. Hayes remain on no bond status. As Mr. Lewis stated earlier, this defendant is currently on probation out of the cab. He received 4 years probation in 2022 for a possession of meth and a forgery in the 2nd degree. He also has another conviction out of 2022 for giving a false name and a forgery. And we're showing on his GCIC an open case from 2023 out of from the College Park Police Department for an interference with custody case. And so we don't have a dispo. We're showing that case is still open. Also looking at his GCIC regarding the case Mr. Hayes had in Texas, a fugitive from justice was filed in 2014. So regardless if he has finally completed all of those requirements, there was a fugitive from justice warrant for him in 2014 out of that case in Texas. And so certainly we believe Mr. Hayes does present a flight risk, given that he is currently on probation. When this incident allegedly occurred, we believe that there is a substantial likelihood that he will reoffend. And given all of that, Your Honor, and the serious nature of this offense, it was alleged that Mr. Hayes tased our victim in his stomach twice. And so we are asking that Mr. Hayes stay on no bond status. If the court is inclined to grant a bond, given the defendant's history, we're asking for a minimum of $40,000 bond with a stay away, and that he cannot leave the state of Georgia without permission, given his history as a fugitive from justice.
May I respond?
Yes, final words.
Thank you. Judge, with respect to the fugitive of justice, I referred to that as a failure to appear earlier. As the court is able to see, hear from the recitation by Ms. Freeman in this case, this young man was confined in DeKalb County subsequent to that fugitive from, convicted subsequent to that fugitive of justice warrant and then released to the street. So we know the net effect of the fugitive of justice matter. And Judge, I understand that Madam Prosecutor says that he has an interference with custody matter. He has no kids. And so we don't have an interference with custody case that we are aware of at this time because he didn't have any kids. And then finally, Judge, since Madam Prosecutor has asked for a bond, in this particular case, Judge, I'm asking for a $5,000 bond. We've already told you where he will reside. We have no problem with him remaining in the state of Georgia and that he has a residence. Judge, but for the events happening in his home, which was not the home of the purported victim at this time, this matter wouldn't have arisen at all. And we don't think that the purported victim will be coming back there anytime soon. Thank you.
All right. Of course, here we have I feel a significant threat of committing additional felonies should he make bond based on his criminal history, fugitive status at some point. Mr. Hayes just can't seem to stay out of trouble. What did the state request? I think it was 40,000.
40,000. Yes, Judge.
All righty. Keeping in mind the purpose of a bond, I am going to set a bond at 35,000. No contact with the victim. Can't leave the state of Georgia.
Great, Judge, and I'll get that paperwork to Attorney Lewis.
And a curfew.
I'm sorry, Judge. I missed what you were saying when Ms. Freeman started speaking.
Oh, and a curfew.
Okay.
So could you repeat it all, Judge?
So $35,000 bond, no contact with the co-defendants, with the victim, can't leave the state of Georgia, and a curfew.
Okay, and what do you want to?
Curfew. Did you hear me?
No, ma'am, I didn't hear with that last part. What did you?
7 to 7 curfew.
7 to 7, gotcha.
Yes.
Thank you.
All right, that's the order of the court. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge.
All right, what about?
Your Honor?
Yes.
Sanders, we received remember the consent bond for him yesterday, and I believe that was the last one on the calendar.
No, Benjamin Smith.
Yes, Your Honor. My apology.
Is that your client, Mr. Lewis?
Yes, Judge, it is. That's the young man that I needed to speak with.